transcription 911 call, which seems to corroborate what the witness is saying as it relates to someone approaching him. And I want everyone to know I can understand someone approaching someone in anger when there's an accident and your loved one is injured. And by the same token, I understand if someone is being approached in anger at an accident. And from the photos that were admitted to the court to review, the defendant was injured as well.
A sentencing hearing can turn on one explanation. In this case, the defendant says he left because he was afraid, but Judge Boyd has to decide whether that explanation changes what the record shows. The defense asks for a chance. The court looks at responsibility, restitution, and what supervision would actually mean. Then the hearing takes a sharper turn when the person most affected speaks directly to the court. Watch how Judge Boyd weighs the excuse against the consequence.
All right, court is calling 2024 CR 3419, State of Texas versus Kevin Curiel. Can I have parties announced for the record for the state? Defense?
Jason Todd for Mr. Currell.
And are you Mr. Carell?
Yes, Your Honor.
All right, you entered a plea of no contest on October 17th. According to the plea bargain agreement, the state was proceeding on counts 1 and count 2. Is that correct?
You see it. I don't recall, Your Honor. May I look at the counts just to be sure?
Yes,
Okay.
because I don't have it listed that way.
And that's not typically how. But I understand.
Here's the invite.
I remember now. I believe there's two victims, and that is correct, Your Honor. I
Okay,
apologize
thank
for that delay.
Problem. All right, so you entered a plea of no contest to both counts 1 and 2. According to the plea bargain agreement, punishment is to be assessed at 5 years. There's a $2,500 fine. State is silent on your application for deferred. The state recommends community supervision, and there's to be restitution to the complainants. Did you understand that to be the plea?
Yes, Your Honor, that is what we understood.
All right. So we are here for sentencing. The state is in agreement to your having supervision, which is a conviction, but they're silent on your application for deferred. So let's get to the crux of this situation. Why should I give you deferred adjudication, counsel?
Your Honor, we've given a mitigation packet to you to talk about Mr. Curiel. That's been given to the state. The state reviewed that before they give that to you. Judge, we come to you today to, first of all, accept responsibility, but also to give an explanation. The first part of this is Mr. Curiel is, he works very hard. He has family members that depend on him. He does have a prior drug offense that I believe is a marijuana offense. So I can't say that he has no criminal history, but he has a very limited criminal history and is an active member of this community. What we're after, the reason for the deferred is to allow him to continue working in his business and in his job and supporting the people around him. The difference between, as you know, a conviction and not a conviction is significant. We do have an explanation for the night. Once again, not to put off any responsibility, but just to explain why Mr. Curiel reacted the way he did, albeit inappropriate if the court would care to hear.
All right, yes.
Judge, what I'm presenting to you, in the end, Mr. Curiel was afraid. We understand that this was a scene in which many people were upset. If what I'm presenting to you now, Judge, the first is a dialogue from the 911 call. The second is the police report from that night. And then the third set are pictures of Mr. Curiel. What it shows is that people were upset at the scene. And then Mr. Curiel was disorientated. When he says, from the moment that I've met Mr. Curiel, he said he left because he was afraid. Our question to him, and the question from the state, which is a very fair question, is why didn't you wait for the police? He doesn't remember the police being there when he left. We went through and I've shown him evidence that shows that it looks like they were there, that he could have waited, that he didn't have to leave. What we're hoping for you to see, Judge, that he had a reason to be afraid. And he made a poor choice. He should have been more patient. He should have stuck around. There's other things he could have done besides leave. We have 2 more exhibits, Your Honor, that the state object to. They haven't objected to any of these that I've shown you so far. That we believe we know who Mr. Leal is. We believe that we found who he is and he has a criminal history. What we're just trying to do to suggest is that Mr. Curiel had a reason to be afraid that is not unreasonable, especially at a scene where people are upset. It's our understanding that Mr. Moses Leal is a family member of the victim, and we understand why he would come to the scene upset. So once again, we're not trying to put off any responsibility. We're just trying to give an explanation. If you want to talk to Mr. Curiel, he is ready to speak to this as well. We just hope that in some way mitigates his choices. Additionally, Your Honor, we have the claim information regarding this case, that this case is settled. I'm going to jump ahead of the state. The state has brought you is going to give you additional restitution. We're not going to object to that. All we would ask for is just time to pay. We weren't expecting that today. We just found that out today. We have no objection to it being included. And I know that Mr. Curiel, I've advised him that he's ready to resolve that as fast as he can. It's just not something that he has at this moment.
And Your Honor, if I may.
Yes.
With apologies to defense counsel. I did not become aware of this particular document until this afternoon.
Okay.
And that's fair, Your Honor.
Is there anything you wish to say? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Kevin Creel.
All right, so how old are you?
I'm 40 years old.
How old were you then?
Had been 37.
All right, and how long had you been a driver when you were 37? How many years?
CDL driver, 9 years. Driver's license since I was 16.
All right, so then you know, especially with a CDL, if there's an accident, you have to stop.
And render it.
Yes.
Yes, ma'am.
So why didn't you do that in this case?
Well, let me start. When the accident occurred, it was my fault. I was having an argument with the passenger, took my eyes off the road. I caused an accident. When I did, my first reaction, check on passenger, I got out and I walked to the victim's vehicle. Are you okay? Is everybody okay? Hold on, 911's been called, and that's when I was met with a man without a shirt. And that's where everything just took a twist. I was scared. I admit I should have waited. So I didn't know that the cops were there. My attorney has shown me evidence that it suggests that there was police there. I didn't know, and I left. If the police were there, I 100% should have waited. And it was a rough night.
Any other questions? Any questions?
State Your Honor.
All right, and the court will note for the record, the court has reviewed the police transcription 911 call, which seems to corroborate what the witness is saying as it relates to someone approaching him. And I want everyone to know I can understand someone approaching someone in anger when there's an accident and your loved one is injured. And by the same token, I understand if someone is being approached in anger at an accident. And from the photos that were admitted to the court to review, the defendant was injured as well. I just don't see what would be the justice, I guess, for want of a better term, and giving him a conviction where if he has the deferred adjudication, he is looking at the full range of punishment. So Is there anything that I'm missing that would suggest to the court that Mr. Curiel should not have deferred?
Nothing from the defense, Your Honor.
Here you go. And I'm basing my decision on granting his application based upon the mitigation packet that's been submitted to the court and based upon the stipulations that have been given to the court as well. So with regards to sentencing, this is what the court will do. And counsel, I'm going to return to you the 911 call and the conversations that were recorded and that were transcribed.
Thank you, Judge.
So counts 1 and counts 2 were run concurrent. Do you have a suggestion for length of deferred? And I'm expecting everyone to be reasonable. And do you have any objection, even though the state is silent, do you have any objection? I know they're silent on your application for deferred. I am granting your application for deferred. They're asking that your community supervision be for a term of 10 years. So state, I'm assuming that you are asking for the deferred to be for what length of time?
10 years, Your Honor.
All right, so they're asking for 10 years.
Judge, we would ask for 5. We believe that in that time, he'll show the court who he is, and if it'll become clear very soon if he's able to do it, and then he'll have the full range available regardless of how long the term is.
All right, this is what I'm going to do.
Your Honor, may I briefly respond?
Yes.
The state would prefer the court to impose 10 years of deferred adjudication because if, as defense counsel claims, Mr. Curiel shows the court who he is and abides by his requirements, then he should be able to come to the court and request to be terminated early from supervision.
That's correct.
Okay. Then we will do it for 10 years. All right. Court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, $2,500 fine, time and money to run concurrent, 200 hours of community service restitution, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. The defensive driving course. There's to be restitution, if any, to Maria Sanchez and Inez Leal. Field visits 1 time per month for 6 months. Regular random UAs. And you can either do the regular random UAs or you can do a patch. The patch costs more, but it gives you more abilities for employment. TAP evaluation, out of custody, and follow recommendations of TAP. Probation, is there anything else?
The tax evaluation already been complete. The recommendation was the with 1-year analysis monitoring requirement.
All right, then that will be the DOEP course. Is there anything else, probation?
Okay.
Is there anything else you need from the court to be successful?
Yeah.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing, in this court, to be successful on probation, communication is key. If there's an issue, you need to let probation know. If you feel as though they're not addressing it, you can always come back to the court. Do you understand?
Yes, sir.
Counsel, is there any victim impact?
Yes, Your Honor.
All right, Ms. Leal? If you could unmute for me, please.
Yes, Your Honor, I'm here.
All right, Ms. Leal, it's the court's understanding that you would like to have a victim impact statement.
Yes, ma'am.
All right, you may proceed.
Okay,
Oh,
hi,
I'm
my
so
name,
sorry. Before you do that, also, there's going to be a restitution hearing.
okay,
Ms. Ferguson, can I have a 30-day reset for a restitution hearing?
March 4th.
All right, Ms. Leal, the restitution hearing is going to be March 4th. Whatever documentation you have, be sure to tender that to the state. And you'll be allowed to appear for the restitution hearing by Zoom. No objections, I'm assuming?
No objections, Your Honor.
All right, you may proceed, Ms. Leal.
Hi, my name is Ines Leal. I am, the reason for the impact statement is I am in agreement with everything that y'all have for the sentencing part. And thank you so much for giving them the 10 years deferred. And the reason why I want the 10 years deferred is because he didn't acknowledge us. Yes, my brother was upset. He was very upset because I was screaming in so much pain. And not once did he acknowledge us. And that is the only reason why I am angry. Still angry because there was 3 females in the vehicle. It wasn't a car full of men or young kids or anything. I'm an old lady with two young girls. Like, he did not acknowledge us. So I just want to say that part. Second is I didn't know the extent of my injuries. Now after the wreck, I needed surgery and I have 6 screws and 2 rods. Before that, I was working 6 days a week, 10 to 15, supporting 10 to 15 hours a day, 6 days a week, supporting my family. And now I'm not able to work. I want to work. I hate having to be at home now. I'm sitting here, I'm going a little bit over a year trying to get disability, trying to get Social Security. I'm behind all my bills, like, since the wreck. And like, I'm glad he got hurt too, but it was his fault. And I'm glad that he's acknowledging that it was his fault. Now, the thing is that I'm disabled permanently for the rest of my life, and I'm still young. And my grandkids are coming. I can't even enjoy parties, barbecues. I mean, and I'm literally not making none of this up. If I could work right now, and I want to work right now, but my body does not let me work. And so now my 2 youngest ones, my 3rd one already turned 18, so he's grown. He can start working or whatnot. But my 2 younger ones are the ones that are hurting because those are the ones that I should be. When I was working, I was spoiling my older ones. But now that it's coming, I'm trying to keep this brief. But my 2 younger ones now that I'm supposed to be spoiling because I've already spoiled the 3 older ones when I was working, and now I'm not able to work. Now I'm gonna have to sit here and live on a set income that I'm not ready for. I don't want to live off of 900 a month and then whatever Social Security decides to send me or whatnot. So that's the reason for the restitution, because you're gonna get to work, you're gonna get to enjoy your family outings with your kids or whatnot. But what about me? I'm sitting here disabled for the rest of my life. I got 6 screws and 2 rods. I'm waiting to get surgery on my lower back. Like, guy, you made a bad choice, and it's affecting you. But you're still getting to enjoy life, and I'm not. And my kids are not, or my grandkids are not. Like, you made a bad choice and you messed up my life. Because I was that woman, that single mother for the past 12 years that wanted to go work. I didn't care about child support. I didn't want no child support. I could care less if he owes me that. The kids that owes me that for the rest of his life or whatnot, I didn't care. I didn't want to depend on that. So I went out and busted my butt to sit there and support my kids and have a roof over their head and get them what they wanted, what they needed, and then some of what they wanted. And now I'm sitting here waiting for a darn check that I still haven't got. And behind my bills, I didn't get my kids nothing for Christmas. Nothing for Christmas because I have nothing. Like, you just don't know. And I don't know why I can't see you. I wish I could have seen you. I can't even see you in the video or when I wish you could see me, the pain that you've caused me and my family. And this is for the rest of my life. Okay, I'm sorry. I'm trying to keep it brief. I have a lot more to say. I have just so much anger for the way that I'm stuck now for the rest of my life. But thank you.
All right,
And thank you for sentencing for the 10 years. That's just what I wanted. I did. I'm sorry that I wanna, I mean, I know he has no priors except for whatever I heard, the marijuana or whatnot, but just, he, what do you call it? I'm very, because I want him to remember for at least 10 years that you've ruined my life, that you're gonna have to go report and do what you gotta do so you can remember me instead of you doing this for 5 years and then for you to sit there and after that you're gonna be oh happy go lucky and oh let's party, let's we're done with the fight. No, no, no. 10 years, guy, 10 years.
all right, so
Remember.
thank you so much, Ms. Leal. Just make sure that you have that information for the state with regards to your restitution. And thank you so much for zooming in. And both the defense and state have agreed that for the restitution hearing, you are able to appear by Zoom. And that date is going to be March 4th. Okay?
Okay, thank you.
You're welcome. Court is calling 2024 CR 0943, State of Texas versus Makai Williams. Can I have parties announced for the record for the state?
Eric Settlement.
Defense?
Zachary Munoz.
And are you Mr. Williams?
Yes, ma'am.
All right, probation, there's an application. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, we received the discovery on the two cases before.
Court will find that the state is in compliance with discovery. Did you review the application for community supervision with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we did.
State, are you proceeding on the indictment as presented?
Proceeding on count one, waiving count two.
Any objection?
No objection, Your Honor.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault on a public servant? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
And also, we're proceeding in cause number 2024 CR 2022. And in that cause number as well, the court will find that the state is in compliance with discovery and state. I'm sorry, sir, on that count, did you review the indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
And state in that cause number, are you proceeding on the indictment as presented?
No, you're on proceeding on count one, waiving counts 2 through 7.
No
Any
objection.
objection?
No objection.
And that cause number, the charge is the same as well. So the same admonitions I reviewed with you are the same that apply to that cause number as well. Do you understand?
Yes, ma'am.
And each cause number, you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in each of these cause numbers?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
In each of the cause numbers, do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, he does.
In each of the cause numbers, do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor, we do.
Mr. Williams, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promise you anything other than the pleas?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each cause numbers, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
In each cause number, the state is proceeding on count one. Punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. The cases will run concurrently. They'll take in consideration in each cause number 2024 CR 2021 000416, 2025 PF 0099 and 2025 PF 00911 and 00912. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Your Honor.
Do you understand that to be the plea?
Yes, ma'am.
Did you review the waiver of appeal paragraph in each cause number with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is requesting that your probation be for a term of 10 years. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then in each cause number to count one, how do you plead? Guilty, not guilty, or no contest?
I plead guilty.
State any evidence.
Containing attachments, Your Honor.
No objection, Your Honor.
All right, in each cause numbers, did you review the waiver and steps with your attorney? Did you understand them and sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Do you stipulate that you are the same person listed in the stipulation as Dwayne Williams?
Yes, ma'am.
All right. In each cause number, the court will find there's sufficient evidence to find you guilty. And in each cause number, the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, we ask to receive full consent.
Anything you wish to say on behalf of your client?
Your Honor, we ask that you follow the recommendation of 10 years probation. My client unfortunately ended up in the system at a young age as a juvenile. That is the underlying sentence that he is currently on parole for. And then these cases resulted while he was in custody at the juvenile detention facilities. Mr. Williams, unfortunately suffers from some anger issues that I think could be addressed while on probation. He had a very troubled childhood, and that is no excuse to go around hitting juvenile corrections facility officers. But I think it paints a picture of Mr. Williams and the unfortunate incidents that have occurred that resulted in the charges before you today. I think placing on probation would be a good way for him to receive the structure that unfortunately he did not receive as a child, and allow him to continue on with his life. He is 19 years old now and wants is hopeful to get this part of his life behind him and start anew.
All right. Do you have any family members in your life, any support system?
Yes, ma'am.
Who?
My mom, my dad.
All right. So then it doesn't appear you had a childhood that didn't have positive influences in it. Were they both positive influences?
Yeah, I met my dad when I was like 14. So it was really mainly my mom.
All right. So your mom, was she a positive influence in your life?
Yeah.
That's either yes or no.
Yes, ma'am.
All right. So why are you doing this nonsense?
I don't know. I just let my actions take place. I was really just mad.
All right, let me ask you this. Do you want to spend the rest of your life in somebody's prison?
I don't know.
Then at some point in time, people will come before me and they say they had a horrible childhood. What I can tell you is some people have childhoods that's more horrible than others. Some people have what we assume were great childhoods. It turns out it wasn't. But at some point in your life, your horrible childhood can't be your reason for committing crimes. You understand? And what is with this 46 on your neck?
That was my football number.
All right, so you go from playing football to being in custody. Did you graduate from school?
Yes, ma'am.
And what are you planning on doing with the rest of your life?
Taking care of my kid
Oh, you have a child?
on the way.
All right. And what does your parents say about that?
Do better.
Hmm?
Do better.
Yeah. So you graduated from high school. Do you have any other thing to fall back on other than a high school diploma?
I got Mac, mechanical air conditioning trade.
Okay. All right. In each cause number, the court is going to sentence you to 10 years in the prison, suspended and probated for 10 years, regular reporting by Zoom or in person, regular random UAs. Each cause number will run concurrent. There's going to be field visits 1 time per month until further notice. 200 hours of community service restitution. You're either going to complete a trade or go to college. And then the court will waive those 200 hours of community service restitution. If you don't want to complete a trade and better yourself so that you can financially support your child, then these 200 hours are going to be spent in the hot sun of Texas, picking trash up alongside the freeway. Do you understand?
Mm.
There's going to be proof of employment within 45 days, no employment as a home health care provider or with minors. I'm going to order parenting classes and anger management classes. TAP evaluation, follow results. Probation, is there anything else? It can be out of custody. Is there anything else you need from the court to be successful? Oh, I'm gonna get to the other thing. Other than that, is there anything else you need to be successful?
I don't know.
All right, and state, do you have the dismissals that were taken in consideration?
Yes, Your Honor.
Yes. And the court is signing the dismissals that have been previously stated into the record. Yes, is there anything else?
Yes, Your Honor. We are more than fine with the conditions laid out by the court. Unfortunately, the timeline of the 45 days seeking employment, we'd ask that that be stayed until he's actually released. Right now, he has a parole hold due to these cases that once they've are in the system entered as rejected, hopefully parole will lift that parole hold from him so he can get out. But until then, he's going to remain in custody while parole figures.
All
that
right,
out.
Ms. Abrams. That time is to start running upon release. The probation term and also, not the probation term, but the time for the employment and his conditions, because he has parole issues. Yes. All right, did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal in each of these cause numbers? With your attorney, did you understand it and sign it?
No.
Because this is plea bargain agreement in each cause number, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, okay? Do better. Court is calling 2020 CR 1544, State of Texas versus Alexander Bryant Streeter. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Judith Wimmer.
And are you Mr. Streeter?
I am, Your Honor.
All right, this is a request for early termination by the defense. Defense, you may proceed.
Thank you, Judge. We'd like to call probation, please.
All right.
Okay.
All right, have you conferred with probation before calling them?
Yes.
Okay, all right. Probation, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Bashan Abrams.
All right, defense.
Ms. Abrams, have you had an opportunity to review Mr. Streeter's probation history?
I have.
And has Mr. Streeter complied with all of his conditions of deferred adjudication?
He has.
Was he placed on probation in May, deferred adjudication, May of 2021 for 6 years?
Yes.
Does the probation department have a recommendation as to whether his deferred adjudication should be terminated?
At this point, they are recommending early termination.
I'll pass the witness.
All right, state,
No questions.
all right. I just have a few if there are no objections.
No, of course not.
Has there been any previous violations?
No, Judge.
All right. Any concerns?
No, Judge. He has no violations, no positive UAs. He's current on all of his fees. He's been cordial on all of his visits with his officer. He reports on time. The officer has no concerns at this time.
All right, thank you. Any further witnesses?
No, ma'am, we rest.
State, any witnesses?
No, Your Honor.
All right, I'd like to call the defendant if there are no objections.
No, ma'am.
Sure, state that.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, what have you learned from being on probation?
Well, the severity of my actions was resulted in the injury of a close friend of mine. Additionally, it damaged my relationship with members of my family and my community as well. The actions that I undertook were as a result of substance use as well, which was affecting my judgment. And every moment since then, I have taken that into consideration in my day. And my commitment, regardless of my circumstance, is and remains to conduct myself with integrity with regards to my personal choices and to avoid substances and discipline, as well as gratitude.
All right. And what classes were you required to take?
As part of my probationary agreements, I was placed on the UA hotline, and I had completed that, and then I was sent to a drug test. I believe it was monthly. That's the most recent thing I can remember.
All right. Any other questions?
Not from the defense.
Up on the state, Your Honor.
All right. Probation, and I forgot to ask this, part of his conditions was restitution. Was there any restitution amount that was owed? Did you pay me?
The defendant was never informed of any restitution.
Okay.
Please let me know if I missed.
No, Judge.
Hey, it happens. All right, so no restitution is owed? All right, if there are no further witnesses from each court, will hear argument. Defense?
Thank you, Judge. The defendant has been on deferred adjudication for a little over 4 years. I'm sorry, almost 4 years. And I think he's been a very responsible probationer in satisfying all of the conditions of his probation.
All right, everyone, if you could please whisper.
I think that he's been a good model probationer. Given his youth and his comments just recently to the court, it appears that he has learned that the behavior he was involved in that led to this offense is not acceptable and can lead to severe consequences. And he has in fact changed his outlook on his personal behavior. Deferred adjudication is designed to have this kind of impact that if someone,
I'm sorry, just one moment. Check. All right, I'm sorry. You may continue.
Thank you, Judge. So deferred adjudication is a process by which a probationer who does act appropriately, have no violations, and completes all their conditions to give them the benefit of early termination. And I believe that Mr. Streeter is a good representative of a person who should be granted an early termination.
All right, state, you are opposed. You may proceed.
Yes, Your Honor, we're opposed to aggravated assault charge.
Okay. Just give me one moment, everyone. Oh, this? Okay, all right. Okay. Is the 226 not available?
No.
Are they in a bench trial, jury trial?
Bench.
Okay.
They've come to the best.
Oh, look at you. Thank you. Look at you making my day. Telling me to push harder, Rashawn. That's all that's like. Push harder. We need you. All right.
It's a girl thing.
Let me just review something very quickly. Any objection to the court reviewing the stipulations?
Absolutely not.
Okay. All right. So state, have you had a chance to contact the complainants in this matter?
Good night.
All right, so this is what I'll do. I mean, he's completed everything and he's been on probation since 2021. And his deferred adjudication was for a total of 6 years. So we're already in 2025. The court will grant the motion, but the motion will not become effective until February 11th. State, will that give you enough time to reach out to the complainants? And are you on any type of GPS?
GPS, like an ankle tracker?
Yes.
No, Your Honor.
All right, so I'll grant your motion on February 11th. And that will give the state time to reach out to the complainants. I will tell you that part of my conditions for you on probation, and this was requested, I think, by the complainant as well, that there was to be no contact with Mr. Kloss, but no harmful or injurious contact with Ms. Streeter. So the no contact with Mr. Kloss, you should probably still abide by that. Do you understand?
Absolutely.
All right. Is there anything else?
No, ma'am.
All right. Thank you.
May we be excused?
Yes.
Thank you.
These hearings show three different sides of Judge Boyd's courtroom. In the first case, the court weighed an explanation against long-term consequences and built a ruling around supervision, restitution, and accountability. In the second, Judge Boyd focused on a young defendant's future and made clear that structure only works if the person follows it. In the final case, the courtroom showed the other side of supervision. When someone follows the rules, completes requirements, and demonstrates change, relief can become possible. That is why these hearings are more than routine paperwork. Judge Boyd looks at the record, the choices, the risk, and the path forward. Comment which ruling carried the most weight and subscribe for more real Texas courtroom breakdowns. Every ruling has a reason. Court Beacon TV shows you both.